I will talk about England and Wales, and I would like to outline some key features, first in relation to standards of judicial conduct, and second in relation to the process of complaint itself. I leave aside the UK Supreme Court, which has a separate guide to judicial conduct and a separate process for complaint. My overall point is that judges are held accountable not just by the Judicial Conduct Investigation Office, the JCIO, but also traditionally by the Court of Appeal. And more generally, that disciplinary issues are best addressed in their broader context, where training, monitoring and support of judicial performance can be reinforced. Turning to standards of conduct, we know that they are a defining component of public trust in a judiciary. In England and Wales, these standards are found in a guide to judicial conduct, last revised in March 2020. The guide covers the three principles of judicial independence, judicial integrity, and judicial impartiality. It also introduces guidance on activities outside courts, perceived bias, personal relationships, activities following retirement, among other things, and it refers also to the bench book on equal treatment. But the guide also expressly states that it is not legally binding. It states that it contains only a core set of principles which will help judges reach their own decisions. This reflects the balance between, on the one hand, the benefits of putting standards of conduct on paper, namely transparency and the express encouragement of professionalism, and, on the other hand, the possible resulting rigidity or loss of flexibility in judicial practice. In 2002, when the guide was about to be introduced, some English judges noted the risk, quote, that the press and even judges will focus excessively on compliance with the letter of any code rather than on any of the underlying principles. The European Court of Human Rights itself recognizes that broadly phrased ethical duties fall within the scope of foreseeable law on the basis that published, therefore accessible disciplinary decisions make these obligations foreseeable. So in the English context, I suggest that there is little merit in defining more precise or over-precise standards of behavior. This is because the standards of conduct within the courtroom and outside the courtroom are also stated and enforced in the Appellate case law. One key feature of the English system is that the Court of Appeal plays a strong disciplinary role on broader fair trial principles. The judicial manner of conducting a trial or adjudicating a dispute, that is, how a judge will engage with the parties or a witness, this may constitute a procedural irregularity which makes the trial outcome unsafe. And a recent example is the case of Serafin against Malkiewicz and others, which went up to the Supreme Court in 2020. The Court of Appeal criticized the judge here for his hostile questioning of the party. His language was, they said, threatening, overbearing, and, frankly, bullying. Although the Court of Appeal praised the way in which the judge wrote his judgment afterwards, he had conducted the trial in a way that was unfair to the claimant and to the presentation of the case by the claimant, who was also a litigant in person. As Lord Reed said, a judgment which results from an unfair trial is written in water, and a full retrial was needed. I would now like to consider the complaint process before the JCIO. The JCIO, the Judicial Conduct Investigations Office, is at the heart of the regulatory framework that was introduced by the Constitutional Reform Act in 2005 to handle complaints about the personal conduct of judges. The Procedure for making and considering complaints is set in a Judicial Discipline Prescribed Procedures Regulation 2014 and the Judicial Conduct, Judicial and Other Office Holders Rules 2014. And I will go through them very briefly, through the process, very briefly with you. There is first a filtering stage with limited powers to the JCIO to dismiss complaints, only, for example, when they are vexatious or they are not serious enough to warrant disciplinary action. If, following consideration of the complaint and making inquiries, it appears that misconduct may have occurred, the complaint goes to a nominated judge of at least the same rank as the judge under investigation. The nominated judge makes findings and recommendations to the Lord Chief Justice and the Lord Chancellor. If the complaint is particularly complex or serious, the case may be referred to an investigating judge or to a 4-person disciplinary panel composed of 2 judicial office holders and 2 lay persons. The judge under investigation must be given a chance to respond, and if that judge is at risk of removal or suspension, he or she can demand to appear before a disciplinary panel. And when the investigation process is complete, the Lord Chancellor and the Lord Chief Justice decide jointly whether misconduct has occurred, and if so, which is the appropriate sanction. And the disciplinary sanctions prescribed by law go from formal advice, formal warning, reprimand to removal from office. Information itself about the actual misconduct is available from the JCIO's annual report and in a disciplinary statement that you will find online. And the JCIO has an ombudsman. He or she oversees that the JCIO has followed its prescribed procedures, and it investigates any allegation of maladministration. I'd like to make 2 main observations on this process. First, one issue lies in the management of disciplinary complaints by superior judges before and after the complaint is addressed by the JCIO. There is, naturally, a temptation to resolve issues informally, since formal action is likely to result in problematical relations between the accused judge and those above him in a judicial hierarchy. However, the informal resolution cannot be done outside the framework of the disciplinary rules. Thus, in one case in 2015, a district judge sat in a social benefit case and the appellant complained afterwards about the judge's questioning. At the preliminary stage of deciding whether the complaint should be transmitted to the JCIO, the superior judge had promoted the idea of an informal resolution, which, however, was not possible at this stage under the rules. As the judge denied misconduct, the relationship with the superior judge broke down, and the superior judge expressed trenchant views in his letter to the district judge. He also relied on evidence which the district judge had not had any chance to comment on to form the view that there had been potential misconduct, and therefore the complaint needed to be sent to the JCIO. Later on, the JCIO dismissed the complaint. However, the cover letter to the decision added that, quote, "It might be some comfort to the appellant in a social benefit case to know that all judges can benefit from training in judgecraft and that the judge will be offered some informal advice in that regard." Efforts were then made locally to enroll the judge on a suitable training course, and the judge complained that this advice to enroll him on a suitable training course was detrimental, improper, and even unlawful. He complained that he was now treated as a problem judge. Again, we see an informal advice being added on the cover letter outside the disciplinary decision itself. This led the district judge to argue that from the beginning, there had been race-related harassment, direct race discrimination and victimization during the investigation. I should add that his claim was dismissed by the Employment Tribunal in 2016. But the case would not have got there if the temptations towards informal resolution and mixed messages had been resisted. This case, I suggest, brings a number of issues into light. First, although the disciplinary rules came into force in 2013, at the time of the complaint in 2015, no training about the disciplinary rules had been provided to the judges handling the complaint. It really showed in the way the procedure was handled, and I would add that this is true for a small number of other cases too. Second, the district judge complained that he was now treated as a problem judge. The question is, was the borderline questioning during the trial typical of that judge? Had it been picked up before? How do you support judges in this position? This case and the Seraphine case I mentioned earlier only draw attention to the need for greater training, support and monitoring of judicial performance. Third, the district judge is now sitting in a different tribunal chamber, and I expect that this is by mutual agreement, but it would be good to know the way the move was decided. My second main observation is that context matters. In this case, the judge was dealing with an appeal to maintain a social benefit, asking questions on sensitive issues. In the case of Seraphine, the judge was dealing with a litigant in person. Another recent case where the district judge showed anger and sarcasm during a court hearing was about an adoption order, another very difficult matter. The adoption order the district judge made was overturned in a 2019 case, CA Child Judicial Conduct, as a result of her behaviour and management of the case. It is not a coincidence that these cases relate to publicly funded work, and as has been noted by others, every branch of the publicly funded sector is overweight to the point of breaking. So what seems to be needed is less informality when a complaint has been made. Instead, we need to look for creative solutions to support judges who work in highly volatile and underfunded conditions. My final point will be on the JCIO statistics. To give broader perspective, in 2019-2020, only 42 investigations from the Judicial Conduct and Investigation Office resulted in the Lord Chancellor and the Lord Chief Justice taking disciplinary action. That's fewer than 3% of all the complaints received, and it represents 0.2% of all judicial office holders. And the bulk of the cases concerns magistrates and fee-paid judges, with 3 cases concerning the court's judiciary. Statistics, however, do not give the full picture. First, overall, most of the complaints made to the JCIO are in fact found to be unsubstantiated, or even if true, insufficiently serious to require disciplinary action to be taken. This might be related to the rise in the number of litigants in persons, but there are likely other factors too. Second, the main reason to dismiss the remaining complaints is Rule 21B, the fact that the complaint is about a judicial decision or judicial case management and raises no question of misconduct. Rule 21B highlights that the appropriate way to challenge judicial decision and case management is appeal to a higher court. In fact, 66% of the complaints received in 2019-2020 concerned judicial decisions and case management. That's 851 complaints out of 1,292 complaints. Third, while there are many unmeritorious complaints, we also know that there is reluctance from barristers to raise any issue of judicial behaviour. Since 2017, both the English Bar and the Senior Judiciary have taken steps to address the issue, and there's a lot being currently said about judicial bullying towards barristers. There is now an online confidential reporting tool, Talk to Spot, which gives barristers the option to record and, if they choose, report anonymously. On the judicial side, there is a whistleblowing policy in place since 2020, and the Diversity and Inclusion Strategy 2020-2025 confirms the willingness of the judiciary to work on judicial behaviour, with an emphasis in this strategy on training and support in order, quote, to support and build a more inclusive and respectful culture and working environment within the judiciary. In conclusion, very briefly, we need to shift informal support measures to preempt complaints rather than belatedly introduce them when a complaint has been made. And those statistics need to be treated with caution. The standards of conduct are high indeed. Thank you.